You send a letter and then it happens. The envelope shows up thicker than usual, right? Feel it in your stomach. Is it over? Did it work? Or did I just make it worse? You open it in pages of statements, screenshots, and printouts. And at this point, most people panic here, right? They think that they lost, but the reality is that in the debt battle, this is where the real process begins. In the administrative process, this is where it begins. Now, I've studied the UCC, I've studied consumer law, I've studied the process between you and a debt collector. I've studied the whole banking process. Even though we still have a lot to learn, I'm gonna show you today how to read these replies like the system does. Calmly, lawfully, and strategically. Now, thank you for watching the video. Remember to hit the like button. Remember to hit the subscribe button if you're brand new. And if you watch this video, I think 98% of you guys watch my videos and don't tap that like button. So just go ahead and hit the like button. All right. Also at the same time, 98% of y'all watch my videos and aren't subscribed. It's free. Go ahead and hit the subscribe button. Road to 50K. I think we're about 400 subs away. Tap into the community, man. We're still growing. All right. Number 2. Even though I'm going to be talking about the UCC, even though I'm going to be talking about consumer law, and I'm going to be talking about legalese and things in that nature, this is not legal advice. Please consult an attorney. This is not financial advice. Whatever decision that you decide to make, it is not because of the video. It is because of you. All right. This is for educational purposes only. Do whatever it is that you want to do with the information that you will. All right. So thank y'all for watching the video. Let's dive into another one. So one of the first places that I want to talk about is a lot of times when I get a lot of questions from people where they reach out and say, hey, I sent the letter to the company and this is how they responded. And I can look at the response, and me just looking at a response from a debt collector, I can tell whether or not they have did their duty. Why? Because I know and understand what I asked for and what they should be giving back. Does that make sense? If you know what you should be asking for and you know what they should be giving back, it just makes the debt discharge process even better. The debt validation process. Let me not just always say debt discharge, it's debt validation, contract verification. All right. So sending your letter isn't the end. So when you're sending your letters to a debt collector, that is not the end. It's more work to do. That's just the beginning of the dialogue. Remember, you are doing this to paint a narrative that they are doing something fraudulent to you, okay? Because you're going to have to take it to court for the most part, or be willing to, or have the intent to, because if you don't have the intent, the opposing party can read that and they'll just keep stringing you along, all right? Now, once the other side replies, how you read and respond determines whether you confirm your position or lose it, all right? I was talking with one of my business partners today. They're dealing with a situation with Navy Federal. Long story short, they basically started a judgment. He sent the motion to vacate the judgment for proper validation. After sending that motion to vacate, they pushed the date back, but then Navy Federals, or not Navy Federal, the debt collector sends them a letter saying, oh, you took too long to basically dispute this. And I basically told him, I said, look, man, number one, at this point, he was saying, oh, I don't need to respond because I asked them. That's one mistake we make. Oh, I already sent the letter, so I don't have to do nothing else. They have the burden of proof to send me something back, so I don't have to send nothing back. No. Number one, that will be emotional, okay? Waiting for them to, if they send you a letter and they say that what you did was wrong, you have the responsibility to reply back and tell them that what you are doing is correct, and for them to prove that it's wrong. Okay, prove that you can't ask, or prove the relevance of the time it took for you to respond to their fraud, and also at the same time bringing up that the statutes of limitations on fraud is infinite. Okay. But in a situation like that, obviously I know how to respond. And I will say in particularly, he didn't necessarily do these two things. He just kind of neglected what he should do after the fact. Never leave a response unresponded to or unrebutted. Okay? But here's what most people do. They get a response and they think that that's the time to panic. They panic and assume the letter means defeat just because they responded back without really doing a true forensic analysis to make sure that this is what they asked for. And they reply emotionally instead of procedurally. But in a lawful process, every reply is just another offer, all right? Even when they send you a letter and they say that what you did was wrong, that is an offer within itself. And when you do not reply to it, you've actually accepted the terms of whatever they said. So you have to reject that offer and basically counter it, all right? Every offer must be accepted, rejected, or clarified in writing. So here's the key principle. Every letter is a move on a chessboard. Your next move defines the outcome. So when you do get a response from a company, understand that that's just them moving a chess piece too, right? If you are playing chess with somebody, it's no point where they just still moving pieces. You have to make it so that they have no more pieces to move. Do you get what I'm saying? Do you understand that this is a game of chess? Why not back them into a corner and make it so that it's checkmate? Because once you checkmate them, guess what? They have no angle out. When you checkmate them before you go to court, when you checkmate them before you go to mediation, you're just going to take the same things that you did to checkmate them privately and say it in court. All right? So let's understand the 3 types of responses. When a creditor or a collector replies, the response usually falls into 1 of 3 categories. Learning to identify which one you received is the one that will keep you in control. All right, so here's what it looks like. The template reply. It has generic language, no signature from a real person, repeats account balance and due date, no original contract or accounting. Okay? They fulfill the communication and not the validation. This is not evidence. This is just noise. Okay? Anytime you get a generic response from a debt collector just giving you the same things and there's no real person signing it, it's a generic response, which is typically what they're going to send first. You send a short follow-up and say, well, hey, look, thank you for your correspondence. The information you provided me does not constitute validation as defined by law. Please provide proof of claim within 15 days. Very simple. Refer back to Exhibit 1 where I validated the debt. Okay? It doesn't have to be an extravagant. You don't have to change up the strategy. You don't have to send a letter. Oh, I sent a debt validation letter. They didn't validate the debt. So damn, it must be another letter I need to send. No, it's not another strategy to do, but to go back and reinforce your original strategy, which is getting them to validate the debt. So guess what? I want you to know that I understand that you have communicated, but you have not validated the debt. I've asked for X, Y, and Z. Please provide that within the next 15 days since you've already dishonored. You can take that angle right there. Another thing they'll do is they'll give you a partial response. So number 1, they'll give you a template response. And number 2, they're going to give you a partial response. In that partial response, here's what it will look like. It will include account statements or screenshots, right? We've seen this before. It may contain a signature block from compliance or legal, but it still lacks a wet ink contract or a full ledger. Now, for those of you who don't understand, yes, they can give you a photocopy of a contract, but under the rules of evidence, somebody must have firsthand knowledge of something to be copied in order for it to be authenticated, okay? Same thing under the rules of a procedure, all right? A person has to sign it back. And the reason why, even if we take it back to a natural person communicating what can only communicate with a natural person, okay? They cannot communicate with a dead entity. An LLC, an entity, a corporation is a dead entity. Dead entities speak a different language than a natural living, breathing person, which is why there's a disconnect if no human actually signs it. Because who do we hold accountable? Legal? This dead entity didn't even have rights in the first place. Okay, give me a real person to respond to me. And when you ask for these things and you ask for the real person with firsthand knowledge to respond to you, that's also something that is not going to go unnoticed. Okay. So when you do send a debt validation letter and they send you this partial response, they're acknowledging your letter, but trying to satisfy you with fragments. Remember, they're just trying to satisfy you. The statements show accounting activity, but it does not show obligation. All right. So anytime you get a letter of a partial response, you want to send a letter back, a notice of insufficient validation, okay? Or you failed to properly validate. Anything along those lines. Notice of insufficient validation, you are acknowledging their receipt, but demanding full proof of contract and authority to collect. Set another 10 to 20 day time frame. You see, I'm not leaving any stone unturned. I'm going to respond back no matter what. Even if I feel like I've won, until I get to the point where I have them default, until I get to the point where they stop responding and they give up, I'm going to keep replying back when it is relevant. I'm never going to let them just say, put false information out there without me rebutting to it. Okay? This is why I want everything in writing, so I can visibly see you saying false information. I can take that and put it in evidence. I don't want you to call me. I don't want you to send me an email. All right? So that notice of insufficient violation, you can use my GPT to put that together. Okay? If you're in a school community, you have access to that. But remember, back to my video yesterday when I broke down the different types of letters. There is notices, there are demands, and there are affidavits. When you are sending a debt validation letter, that is a demand. After this, when they start to say BS, you put them on notice about information that you understand about what is happening so far. And then in the end, there's affidavits. Affidavits is what's going to break down your truths, what you understand, pretty much your statements and your claims. And this typically is the information in the record. All right. So let's talk about what a verified response looks like. Now, if you've gotten this far, hit the like button, hit the subscribe button if you haven't already. Comment down below if this is helping you as well. All right. If you're watching this in the premiere, comment in the premiere. All right. Now let's talk about what a verified response looks like. And if the response doesn't look like this, then more likely they are not validating the debt properly. So number one, here's what it looks like. It includes a copy of the signed agreement that comes with a notarized or sworn statement from the creditor and provides a full chain of ownership if the debt was sold. Meaning this is legitimate verification. Okay? It means that they have met the initial burden of proof. Now here's the next step. You get the copy of the signed agreement. It comes notarized or a sworn statement from the creditor to let you know that that is the actual copy of the original. And they provide that full chain of ownership, okay, which will break down, especially if it's sold, who is the legal holder in due course. Now that they have done this part and they follow these instructions, you want to make sure to review it carefully. You want to make sure, number one, is the signature yours? All right? Is it your wet ink signature? Because sometimes they finesse. Number two, does the accounting match the claim? And number three, is the party identified same one you contracted with? If not, you have grounds for further clarification. If yes, you can negotiate or settle on your terms. Remember, there's two ways that you can go about this. You can go deeper and you can attempt to discharge, or you can attempt to settle or negotiate your terms. Now, your terms could be to use a negotiable instrument, or your terms could be for them to break it down 50%. Okay? Proof doesn't end the process. It defines the next lawful step. Okay? So when you get a verified response, okay, you want to make sure that it's meeting the certain aspects that you know will make it true. Okay, don't just like take what you get and then just think that that's a verified response. Okay, and a lot of times people may think that this is the proof, and once they get the proof, if they give you the proof, if they comply, that they have no chance of winning. Okay, and at this point they may feel like, damn, the game is over, they got me. But in reality, this is where calm analysis and proper documentation will still give you control. What verified really means is verification isn't just a declaration of guilt, it's just a form of evidence, and it only proves that a party has some documentation, and doesn't automatically confirm that the document is admissible, accurate, or enforceable. Under ordinary evidence rule, a document must be authentic, proven to be created and signed by the right people. That's another key. They may give you a photocopy. It must be accurate, free from alteration. It must not have changed since the time of it being sent to you from now and the inception of the agreement. It should be complete. It should include full contract and accounting, not excerpts. And it should be presented by a party with standing, the right to enforce it. So another thing that should be key is that they can probably provide this verified documentation, but they should have legal standing to collect on a debt or even have the information. Okay. How to test verification is number one, you want to check the signature and the date. Does it match your own signature, and is the date consistent with the agreement supposedly made? Another thing is you want to confirm with the party if the sender of the original creditor, or is it assignee? If it is assigned, is there a proof of assignment showing the legal right to enforce? Typically, if it's a debt collection company, more likely it was assigned to them if it was actually assigned. You want to examine the accounting. Does it show the original principal and the exact transactions leading to the current balance? Are these unexplained fees, or are they interest entries? Anything that is unexplained, anything you don't understand, you question and you ask them about it. Do we dive into the authentication? Has it been notarized? Okay. Or is it an affidavit of records? Custodian. Okay. Was the affidavit sworn before an officer or just stamped? These are some key indications as if a document is fully authenticated, meaning that somebody with firsthand knowledge seen you copy it, okay, seen you sign it. Then you want to compare it to your own record. If you keep your documents, does any term, amount, date conflict with the archive paperwork? If any of those pieces are missing or inconsistent, the verification is partial and not complete. When using verification to your advantage, even if the paperwork checkouts, you can still make it a lawful win for yourself. Number one, it's a procedural win. You confirm that the process works, you demanded evidence and received it. That builds your record of lawful conduct in good faith. Doing this lets you know that the process works. So it is a win. It lets you know that if you do the process to the right people who won't give you the documentary evidence, you know what you should be getting and what you should be expecting for the next time. So yes, you win based off of that. But then we talk about the negotiation aspect. It's going to give you more elements to negotiate. With verified proof, you can propose a settlement on your own terms, payment plan, reduced amount, or even paid as agreed, reporting notation, because you are acting as a cooperative party and not really an adversary. It's important that you use this to your advantage for negotiation, because even if you lose, showing your dedication will prove to them that you are willing to go the distance, that you're willing to do your research, you're willing to take them beyond that. So sitting down at the negotiation table and saying, hey, look, we can either negotiate, or I can go ahead and start really diving deep into some of these infractions and violations that you have on me, or we could just go ahead and negotiate so you guys can get paid and we could be done with this obligation. Okay? Y'all won't get any letters from me, and I won't receive any letters from y'all. That's all I want. And I want it off my credit report. So how much do y'all want? How can we come to an agreement so that we both are happy? Okay? Number C, compliance win. If their documentation contains any inaccuracy, you can use that as grounds to request correction or dismissal. For instance, upon review, the statement appears inconsistent with the original agreement. Please verify the attached highlight entries. This keeps a burden of accuracy on them. And number 4 is a tax or an accounting win. A verified response helps you know the true numbers. That means that you can track exactly what is being reported on the IRS or 2 credit bureaus and ensure it is accurate, preventing any future surprises. Now here's how to respond lawfully. If the verification appears legitimate, acknowledge the receipt in writing. Let them know, thank you for sending me a letter and provided me the documentation. Restate that you are seeking lawful settlement and closure, not avoidance. Offer your proposed terms or next step in writing. This keeps the tone cooperative and builds a record of reasonableness. You are being reasonable, and it's important if the dispute ever escalates, because what they'll say is that you try to breach the contract, you didn't move in honor, but you have documentation of you moving with honor, you actually formally thanking them, you being reasonable. Because look, if y'all provide, like I said, I conditionally accept your offer if you can prove X, Y, and Z. Now, I'm telling you this right now, if they prove X, Y, and Z, right, and you see it as proof, then do what you conditionally accepted to do. And that is the point, right? If they want to get paid, then they just provide the documentation. It's very easy if you own the obligation. So it'll look something like this. Thank you for your recent correspondence and your documentation. I acknowledge the receipt and I'm reviewing the information for its accuracy and remain open to lawful settlement. Please confirm that no additional charges will accrue while this review is pending. This is super important, especially when you want to kind of slow down interest payments and things of that nature. You don't want it to build up and make it even harder for you. You using this language is very helpful. Another thing you want to notate is if you spot errors, okay, when you see some discrepancies, mark them clearly on top of the document, write a short notice identifying each inconsistency, and request a written clarification. This transforms the potential weakness in their case into your documentation of diligence. Even if the claim later proceeds, you can show that you've examined the evidence rather than ignored it. So if you ever do get into a point where you're like, okay, I'm done responding, you have the evidence of you examining what they sent, and you can pretty much highlight, hey, this was irrelevant. I always tell you to respond. The lawful mindset that you need to have in order to win. A win is not always walking away from the debt. It's proven that you acted in good faith, demanded proof, reviewed evidence, and documented every step. That's truly a win. It doesn't always have to be you going the distance, because sometimes, right, you do lawfully owe somebody, whether the something you contracted to, something you didn't really recognize. But if you say, hey, look, I'll conditionally accept X, Y, and Z, and they provide that, then move in honor. Okay, we're gonna talk about how to be able to take that situation, and you could take this situation and you can negotiate. Okay, or you could take that situation and they're gonna do something like not comply. Or you could take this situation and it could reveal more about it that you can also question. Okay? But ultimately, this is so that you can move in honor. Okay? And if you're moving in honor, then the courts will reward you for moving in honor, or even the opposing party. You won't have to worry about your account getting shut down. You don't have to worry about never doing business with them again. You could talk about doing, things in a different way. Okay? Another question that I have is, wouldn't this somehow prove us being right about the obligation? Can we use this in our argument? A verified response is a proof of agreement, not proof of who created money, okay? Unless you explicitly ask for that. Because when a lender produces a signed contract and supporting accounting records, they are showing that a legal obligation exists between you and them. It demonstrates that both parties agreed to a specific terms of credit or lending. That's what verification means in consumer or commercial law. But it doesn't necessarily mean that you have to quote unquote use your dollars, okay? Consumer credit systems do use your promise to pay as part of the accounting process. So it's accurate that your signature allows a bank to record an asset and matching liability on its books, because that's how all credit issuance works under a double entry bookkeeping. But this doesn't cancel the agreement or make the bank's claim illegitimate. It just explains how credit creations functions inside the system. Every borrower and lender has a role to play. Okay, so here's how to use this constructively. Number one, confirm that the lender followed lawful procedures. This is your biggest argument against them, is whether they have followed lawful procedures as it pertains to them being a lender, them being a financial institution, and them being in the contract. Making sure the balances and interest and calculations are correct. Ensuring the party contacting you has legal standing. Negotiating settlement or corrections from a position of clarity, right? What you can't do lawfully is argue that the bank owes you because your signature created the money. That's not the point, okay? I know we talk about this, we may understand this, we may know that we're the source of the value, but you cannot use that as an argument, okay? Where your real leverage sit is in the documentation, the timing, and the accuracy. Not claiming that the loan is void, but if you keep perfect records and verify every claim and respond within lawful time, you protect yourself from unlawful collection and maintain the option to settle dispute errors or even rebuild credit on fair terms. So what happens is you just doing the process, because they are criminals and they're doing things unlawfully, they more likely are not going to give you the proper documentation. They're not going to be right on their timing, nor are they going to actually fulfill the accuracy portion of things. Okay. Now, I wanted to, and I may do a separate video on this, but here's some other things to notate. Let's just say they do provide the verification. They do provide, all the documentary evidence that may prove to be, that the debt is valid. Okay. A lot of my angles that I come from is, okay, yes, you could prove that the debt is valid, but wouldn't that just reveal that we funded the loan, that you would be double dipping in a sense? Wouldn't that essentially reveal that there is some unjust enrichment going on? Okay. Now, unjust enrichment is on the equity side of things. And when you think of equity, you think of fairness. You think of, thinking of that pendulum like this. Okay. Is it balanced? All right. Equity supplements the UCC under UCC 1-203, I believe. Oh no, UCC 1-103, I think. One of those. All right. But ultimately, you can use equity in a case against a debt collector, a debt validation process, conditional acceptance. Okay. If a creditor has shown to unjustly and be enriched, then the court can order restitution rather than enforcing a nominal debt. So now you can flip the script onto them. But I always talk about unjust enrichment. Let's talk about some other things and other angles that you can use as well. All right. And I'm gonna go through these quick. So open your ears. Number one, a breach of contract in accounting, showing the creditor didn't follow their own books or contract terms. Useful when ledgers show errors. Another thing, fraud or intentional misrepresentation, where the creditor knowingly lie about something. Okay. Number three, conversion or wrongful possession. Less common for debts, but possible if funds were taken and misapplied. Okay. Meaning it didn't get loaned out to where it was supposed to be. Constructive trust and tracing. To require disgorgement where particular proceeds can be traced to the defendant. Okay. Declaratory judgment and injunction relief. To get a judicial declaration about rights or to stop further collection. Set off and recoupment, reduce or eliminate a claim balance by asserting a related claim. Statutory claims using the FDCPA, Truth in Lending Act, the Real Estate Settlement Procedures Act, I believe. State consumer protection laws often give remedies, statutory damage, and attorney fees. So typically what happens is through violations and things of that nature, this is how you can be able to flip the script from the debt to their violations, okay? Each theory has proof burdens, but this is why you stack them rather than just rely on one, okay? So yes, unjust enrichment may be the key, but you can also use things like constructive fraud, bank fraud, swindles, mail fraud, transmission fraud, breach of contract, violation of contract, not showing the proper accounting, the statutory claims, the different violations, non-compliance. You throw all of that in there. So even if they do provide things that may seem to be true, right, that may seem to be right, you pretty much have a collection of other violations that can outweigh the obligation itself. Okay. When a creditor produces documents, they expect you to shut down. Think of it as evidence that you can test. Here's what production can reveal. Chain of title gaps. Who actually owns the obligation, which is very key. Number two, accounting inconsistencies, right? If it's interest or fees. Duplicate recovery signs. If they charged off, claim a tax loss, then sought full recovery, or altered and unsigned agreements. Those discrepancies, if document, feed an unjust enrichment, fraud, or an accounting claim because it shows that the defender paper trail doesn't support the asserted entitlement. All right. Typical problem patterns that support an unjust enrichment argument. Charge off, then collection without proof of assignment. 1099 issued, but collection continues. Two parties seeking the same payment. When you ever have the original creditor and the debt collector both demanding payment or producing conflicting ledgers. Fees or interest that are unsupported by an underlying contract or ledger entries. Invoices or statements that are backed filed after the fact, post-dated or inconsistent entries. Okay? So there's obviously way more that I can talk about, but I'm just kind of spitballing a couple of things at you guys so that you can know that even if they do send the required documentary evidence, there are so many other things that you can use against them to eventually get them to not comply, give up, or not be able to just get a clean default against you. Okay. So I'll save that for another video, but let me just go ahead and talk about, how to really just wrap everything up, how to make sure that everything is solid. Okay. Number one, how you're going to read the documents like a professional is you're going to make sure to know who the sender is, who the original creditor is. Is it the original creditor or is it the debt buyer? Most likely, if it's the debt buyer, you have an easier challenge. Their signature, is it a human name in position? Because it has to come from a person. Okay? That's how you know that somebody's actually reading your stuff. Number 2, are they having copies of billing statements or original contracts? If you ask for the original contract, you're not asking for a billing statement. Dates, do timelines match your original correspondence? That's very key. Tone, are they confirming facts or are they threatening consequences? You are not reacting to tone, you are reviewing for evidence. Your job is to determine whether the claim is verified or still unproven. Because if it is verified, then you know how to move accordingly. You have to go down this unjust enrichment. You may have to go and use the negotiable instruments. You may have to settle in a different way, but only when it gets verified or validated. If it is not verified or validated and not unproven, then there's no point of you doing any other bill of exchange, negotiable instruments, no coupon remittance or none of that. All you have to do is continue with the verification and validation, and they are literally destroying their own case, okay? Your 3 options after reading. You can either accept and you can negotiate. If they produce verifiable proof, you can settle with documents and terms. So you can settle however you want to, whether you want to use a bill of exchange, go check or whatever the case may be. Your dollars, whether you want to bring the price down, right? This is the time where you can actually have some room to speak about how you want to pay. If you don't want to use the dollar, then tell them that you want to use different methods. If they decide to accept it or not, this is when you go down another road of conditional acceptance where they have to prove that a negotiable instrument or a bill of exchange doesn't work for it, okay? Number 2, you can reject and request more info. If it is incomplete, respond with a notice of insufficient validation. Don't be afraid to send them a letter and follow up with them when they give you a BS response. Don't be afraid to reject what they say, okay? Number 3, record the silence or default. If they never reply again, create an affidavit of administrative closure, create a certificate of non-response. When you do not get a response, send them a letter, letting them know, hey, look, I sent the letter on this day and you guys did not respond. This is what builds a record and shows that they did not respond or comply. But guess what? If they don't respond or comply to that, or even take you serious after that, they're literally making it even worse for them. You go in a courtroom and, people think that they're not going to be able to speak in court, whatever the case may be. But most times the judge, most times the mediator is going to allow you the room to speak and allow you the room to be able to come back. They're not just going to say, oh, well, they're right. Ding, ding, ding. Hit the gong. No. I've been in situations where when I communicate and I say my part, the judge, or when the lawyer would say their part, the judge will look at me and say, do you have anything to say to that? It gives me an opportunity to say something. And the same thing for the lawyer. When the judge feels like, damn, it may look at the lawyer and say, do you know what I mean? And then the lawyer gets to fumbling around. Oh, well, the judge will call the lawyer out and the judge will call you out too. So each option is lawful, calm, and structured. No emotion, no escalation, no record keeping. This is actually becoming a long video, so let's go ahead and wrap this up, man. The psychology of control. When you understand correspondence, your fear disappears. Every letter becomes data. Every page becomes a piece of evidence, not a threat. You're not waiting for their decision. You are documenting your position. It doesn't matter what they do, whether they discharge your debt, whether they bring the ledger down to 0, whether they do what it is that they are supposed to do, you do what you're supposed to do. That is the essence of lawful confidence. We're not waiting on them or hoping for them to respond a certain way. We are just going to do the process. The process really doesn't require their response in order for you to get what you want. Okay? So, as we wrap up, let me just show you guys the practical framework. Okay, number 1, stage 1 is you receive a claim. They say that you owe X, Y, and Z debt. Okay, the next thing you want to do is you want to log the date and the sender. Who sent it to you and when did they send it? Number 2, you want to send them a debt validation letter a couple days later and keep proof of mailing, that certified registered number. Number 3, you're going to receive a response from them. You either want to categorize if it's a template, if it's partial, if it's verified. This breakdown would be in the school community. Number 4, you want to follow up with the appropriate notice. If they sent you a template, you need to send them a letter letting them know that they haven't properly validated. Okay. The second thing you want to do is they send you a partial response. You want to send a notice of insufficient validation. Okay. And if they send a verified response, you start to negotiate, okay? Or you ask for more clarification. You always follow up, never leave any stone unturned. Number 5, closure. Archive, and if silent, create an affidavit of record. Let the record show that they stopped responding, okay? That they stopped doing their duty. You understand what I'm trying to tell you? Control doesn't come from emotion, it comes from documentation. Every time you respond correctly, you prove you understand the system better than it understands you. Now you know what to do when they reply, how to read it, how to categorize it, and how to respond with order instead of fear. In the next lesson, we will talk about the unjust enrichment, how to be able to challenge when they pull this stuff up, how to be able to use this against them. All right, because we got a lot of people that may, send a debt validation letter and they get a response back that may not be as favorable. They get a response back and they panic. And I don't want you guys to panic anymore. So my next couple of videos is going to help you guys understand what these documents look like, understand how to be able to use this against them, and pretty much put you in a position to win. So make sure to hit the like, make sure to hit the subscribe button, push this out to as many people that you need to know, share this so that people can be able to see how to be able to challenge debt collectors and what to expect. All right. So that we can build more confidence in the challenge process. Okay. Number 2, if you want to learn more about this, and again, this is if you want to learn more. This is not for the non-believers. This is not for the people who need proof or convincing. I'm not trying to convince anybody. If you watch my video all the way through, then you already understand that we are a serious community. Okay, we are dedicated to learning consumer law and actually challenging debt collectors. Okay, so if you want to tap in, you can continue to get this free game every single day, Monday through Friday. Just hit the subscribe button. It's completely free. But if you want more and be attached to a community, tap into the school community. We are at 995 people. And in 5 more people, it will not be $27 a month, because I only want serious people in there. I don't want people going in there not taking it serious. Okay? Because when you pay attention. And I want people to pay attention in there. I don't want people to just join it so they can be a part of a community and hope that somebody's going to do the work for them just because you spent $27. Okay? So tap into the school. Lastly, if you want to work with me one-on-one, the link will be in the description, or shoot me a DM on Instagram. Okay? Shoot me a DM on Instagram, but come correct. All right? I get a lot of DMs, and what will separate you from anybody else? You know what I mean? So I can reply to every single DM, and honestly, I had the mini chat going, but I slowed down on the mini chat because I wanted to talk to y'all directly. So the application probably is going to be the best thing. If you want to get in contact with me or my team, tap in with that application down below, answer your questions, and we get the ball rolling. Thank y'all for watching the video. This has gone for a little bit too long today. Leave a like, hit the subscribe button, tap into the channel. I love y'all, and I'll see y'all in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month, if you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now, because nobody's coming to save you, but you can fund yourself.